Hi, my name's Tracy Reinert. I'm a lawyer with Devry Smith Frank, and I've been asked to speak today for Askinonia on combating senior abuse and building resilience. Um, as I mentioned, I'm a lawyer in Barrie, and we have offices in Whitby and Toronto also. But I also do house calls for those who require them. So you don't have to come to Barrie if you need to speak to me. I do offer free consults for people who want to meet and discuss any issues whatsoever as far as it's related to my practice. My practice is mostly estates. So I do estate planning, wills, power of attorney documents. I do estate administration, helping people administer estates as estate trustees or administering them ourselves out of the office on behalf of the estate trustees. And I also do estate litigation. I also maintain a small not-for-profit charity law practice where I advise charities on corporate governance and other issues. But the largest part of my practice is litigation. And I am somewhat known as an elder law specialist, which is a very recent thing that has been coined by the Bar Association in Ontario due to the overwhelming demographic of seniors that Ontario now has. So they have their own subset of litigation issues. Um, and the primary proponent of elder law is the Advocacy Centre for the Elderly in Toronto. They have an office. But when people ask me who should they, and it's one of the questions I was asked to answer, what should I do if I have concerns about someone taking advantage of my senior parent who lives independently and has dementia? I advise they call the Advocacy Centre for the Elderly. They are like a legal aid association specifically for elder issues and elder abuse issues. And they really have an excellent list of contacts and information to provide to people about what to do, what steps to take. And if they need a lawyer, they'll refer you. And if you're in Simcoe County, often I will get that call for that referral and see if I want to accept it. So elder litigation often arises over seniors becoming incapable because of health issues, a stroke or Alzheimer's or dementia, and they've lost capacity. If they haven't named an attorney for property, they need to have a guardian appointed. That's a huge part of elder litigation, where somebody needs to be appointed as either a guardian for property or a guardian for healthcare. It often happens that somebody gets hospitalized for a fall or an injury, and the government, the health team decides to tell them that they're not able to manage on their own, that they have to go into long-term care or make some kind of arrangements for their care because they're no longer able to be independent. In that case, an attorney for healthcare has to make that decision. Attorneys for healthcare make all the decisions about property and nutrition, shelter, not property, healthcare, shelter, medical decisions, healthcare decisions, what you wear, what you eat, what medicines you're taking, all those kind of things are what your healthcare attorney does. The biggest decision, of course, is where you live. And you need to have somebody appointed either by a power of attorney or by a court to have that decision made for you. If you don't have an attorney for healthcare, you don't get one appointed. The public guardian and trustee is the option of last resort for somebody who doesn't have anybody and they're already incapable. So they manage a lot of things for seniors who don't have anybody else, but they're really not the best option for anybody. They are bureaucracy. They are in Toronto. They very rarely travel out of Toronto, so they will never get to know you. They will make inquiries from a distance and make phone calls, but they really don't know you at all. So they're not really, they will look out for your best interest as far as they are capable, but if they don't know you, there's really a limit to what is in your best interest. So guardianship applications are a big part. The other huge part of elder litigation is abuse of attorneys who have been named, unfortunately. So I work with the Red Cross also, and I get a lot of horrible abuse stories and clients from them, of people that are being abused by family. Um, Sometimes it doesn't happen that people find out somebody was being taken advantage of, or things were changed by an attorney until after death. So it turns into estate litigation. But it all comes from an abuse of an elderly person, unfortunately. So, um, question number 2 is, how often should I update my will? Um, to segue into a completely different topic, it is important if you want to make a will, um, that you see a lawyer to do it. If you Anything is better than nothing, but seeing a lawyer is the best protection that you're going to have. A lawyer will make sure that you're capable of giving instructions, make sure that nobody's forcing you to do something, which often comes up in elder litigation where somebody has been forced to change their will, because child has said, you can't live with me unless you change your will and give me more, unless you pay me for the honor of taking care of you. That is undue influence, that is duress, that is something that lawyers are trained to check for. And if somebody challenges your will after you're gone, the lawyer can testify that you acted in your own best interest, that you named the people that you wanted, that you made the decision that you wanted, that you were capable of doing that. So if somebody sues on your will and a lawyer did it, they will actually be suing the lawyer too. And the lawyer will have a lawyer, and that's an excellent defense for your will. If you just do it at home, that's very difficult to prove, and often is done incorrectly. So update your will. Like I said, I offer free consults, so I encourage my clients to come in every 5 years. That's kind of my standard, just to go over things. But when I do a will, I intend it to last for the rest of their life. So I have contingencies and redundancies in my wills when I plan, so that if your kids predecease you, you don't have to come in and change your will because it's already going to your grandkids if that should happen. So we do a lot of that kind of planning when I do wills. But if something big does happen in your life and changes your life, obviously you should go see your lawyer and sit down and talk about how it might change your estate plan. So every 5 years you should have that conversation, and have it with yourselves, with your family at least. And if you need changes, speak to your lawyer. And if they offer free consults, just go in and talk to them and touch base on where you are, and where things might change in the future, and what plans you might want to change in the future, because sometimes it's not directly applicable at that time, but when you sell your house, you might want to change your estate plan. So any kind of big action, as far as finances, a big inheritance from your own parents or from somebody, a lottery win that we all dream of, those kind of things, you should definitely speak to your lawyer. Anybody passes away that is in your will, especially an estate trustee, you should make sure. Like I said, I have contingencies. I have alternate estate trustees always named in my will. But if one of your estate trustees passes away, you should probably name another alternate just in case. So any kind of experience like that should trigger an appointment to speak about your estate. Estate planning is part of it, but I refer to it all as personal planning documents. So there's the will, the power of attorney for property, and the power of attorney for healthcare. And the powers of attorneys are arguably more important because there's legislation to govern where your money goes if you die without a will. But if you don't have an attorney for property, you're leaving it up to other people about who takes care of you when you're incapable. And like I said, the last option is the public guardian and trustee, which nobody wants. So the first is the power of attorney for healthcare, and that's for making, as I said, your shelter, nutrition, medication, clothing, all those decisions that you make in your day-to-day life. If somebody needs to make those decisions for you, that's your attorney for healthcare. So it should be somebody who knows you very well and knows what makes you happy, and could take care of you if you were incapable. Of course, where you live is going to be the biggest decision. So this is something that you should talk to your attorneys about. If you don't want to go to long-term care and you want to stay home until you pass, that's something that is eminently doable in this day and age with so much home care services, and people have things called nanny suites, and they can have mom or dad move in with them, and they can hire people to help them so they don't get burnt out. Um, but obviously, it's going to be easier for somebody to um, send their parent or loved one off to long-term care. You want to make sure that the person that you name knows your wishes and is willing to respect them. Um, you can do what's called a healthcare directive, an advanced healthcare directive. Some people call it a living will of what your wishes are when you're incapable. I do include a small living will in my attorney documents, attorneys for healthcare, and it does say that if I'm on life support, I don't want it to be maintained if there's no hope of me recovering to a meaningful existence. So most people agree with it. Most people keep that in there. And if the attorney is having um, issues with actually making that final decision, it's written there in black and white. And also the hospital can rely on it if they get cold feet, and they can try to enforce your wishes because they will have a copy of your attorney for healthcare document. Um, the other document is the power of attorney for property. About attorneys for healthcare, I forgot to mention that you can also name more than one, and you can name them jointly. You can name them jointly and severally. So if you have more than one child, you can name them jointly and severally, and any one of them can make those decisions. So if you're fairly young and in need of care, um, and it's going to be something that your kids can trade off on, it might be a little bit better so that they can exchange responsibilities or divvy up the responsibilities between them. That is sometimes a really good solution for attorney for healthcare, as long as you trust them to respect your wishes and as you express them when you're capable, and they understand you, so your values and what you care about in your life. If it's impossible to name somebody who knows all those things about you, an advanced healthcare directive can be as detailed as you wish. I once did a 16-page one for somebody with Alzheimer's who didn't have children and was worried their spouse would pass away while they were ill. So it is possible to outline all of your wishes. If this happens, if that happens, when it gets to this stage, when it gets to that stage, and your attorney is supposed to honor those wishes as they're expressed if they are able to do so. So that's a way that some people can exert a little bit of influence over their attorney and direct things when they know they're not going to be capable. So a power of attorney for property is to manage your finances. So this is by far the most important document and the most important obligation that you're going to give somebody, because you're still alive and you still need your money, and somebody else is going to be managing it on your behalf. And they're going to be able to do everything that you can do with your property. They can sell your house, they can mortgage your house, they can empty your bank account, and they can leave you destitute. It's a huge role, and it should be somebody that you trust. And if you don't have somebody in your family, somebody who has moral, ethical, and professional obligations to keep those assets safe for you. So if you don't have family members, you can name an advisor, a trusted advisor. I do it for a number of my clients. I'm often an alternate if they only have one child or they just have their spouse. So if something happens, they know that somebody will step in. I'm happy to help in those circumstances, and a lot of trusted advisors are. Banks also do it, but you won't get the kind of one-on-one attention that you can get from a trusted advisor. I'm also acting as attorney for healthcare for a number of people, and I actually go to their Christmas dinners and go to their annual health conferences and take calls once a week about their menu and their dosages and their dentist and their pedicures and all those things. So I'm happy to be honored and privileged with the ability to do that. And I don't charge anything other than what is legislated to permit a power of attorney for property to do. And I don't charge at all for power of attorney for healthcare. It's just something that I feel I can do for my community, and I'm happy to do it. But For the most part, it should be somebody who knows you really well. If I'm acting in that capacity, if I know I've been named in that capacity, I have my clients fill out a lot of paperwork to put in the file to remind me of who they are, what I know about them, what are their hopes and dreams and expectations and everything that they want out of life. And I try to make sure that I provide that to them as much as possible. And everybody should have those kind of documents for their attorneys to give them some guidance when they're acting for them. And as far as capacity, I didn't touch on that, and I should. Uh, you are always presumed capable until somebody says you're not, until somebody proves you're not, actually. So in the case of a healthcare decision, it's up to the person providing the healthcare whether or not you're capable of making the decision they're asking you to make. So if they ask you about a dosage change on your medication, they have to be comfortable that you understand what that medication does for you and what are the consequences of increasing or decreasing that dosage and what would happen if you went off it. You have to understand and appreciate the consequences of answering the question that they're asking and not answering it also. So if you can't pass that test, they will ask for your substitute decision maker to come in. If you don't have an attorney for healthcare in emergency situations, the Healthcare Consent Act applies, and it will be the first person who is closest to you by marriage or blood or adoption, who is over the age of 16 and available and willing to make that decision. So your spouse first, your children next. Children and parents are equal. And then your siblings, and then so on by degree of sanguinity. So but it is up to the healthcare provider. Although some people will come to a point in their life where they're assessed and found to be incapable of making any healthcare decisions, usually people retain the ability to say what they want to eat and what they want to wear until an end of life, but perhaps they lose the ability to appreciate the consequences of refusing treatment, for example. So a power of attorney for property is a more stringent test. You have to understand and appreciate what you own, how much you have, what your obligations are, what your responsibilities are to dependents, what kind of bills you pay, what kind of income you have. You have to understand that all. Not, you don't have to memorize all those numbers, but you have to have kind of a general sense of it and a general sense of how to manage it in order to pass a capacity assessment. And if somebody has concerns about their capacity, then they can ask a capacity assessor who's hired and trained by the Ontario government to give the test for all types of capacity. They can be retained to provide an opinion. And in the case of a court litigation issue, a capacity assessor is kind of the gold standard. So with my clients, I hold on to their power of attorney for property until it's needed. And I do not turn it over until I determine that my client is incapable or have been provided with an assessor or doctor's opinion that my client is incapable. So I will go see my client and perform a capacity assessment before I turn that over. I won't just take the attorney's word for it, because that document comes into effect as soon as they have it, they can rely on it. So even while you're still capable, if you give your children your attorney for property, they can go empty your bank account and sign a contract and buy a house and in your name and all of those things that you can do in your name. So it's important that a trusted advisor like a lawyer or somebody be kind of the gatekeeper on when that attorney can start acting, because you don't want them taking it and abusing that authority, which is unfortunately very common. So you should tell your kids when they're named. I was asked, when should I have a conversation with my adult children about my will, etc. You should probably tell them at that time and go through your expectations when you name them about what you want. As far as a will, it's bad to have surprises at the end of the day. If you're going to do anything in your will, like cut out a child or anything, it is very important um, to see a lawyer to do that, so that the lawyer can attest that you knew what you were doing and you did it on purpose. There are no forced inheritance laws in Ontario that would force you to give somebody money at all. So, and it is important in will challenges and attorney challenges that the lawyer be involved with the drafting, so they can defend your wishes if necessary. If you die without a will, there is succession law reform legislation that says where your estate goes. It goes to your spouse and children in priority, and then to your grandchildren, and then to your siblings. If you are worried about that, you can ask me about that by phone or by email. I was asked what's the difference between the advice that I provide and the advice that a financial advisor provides. A financial advisor should never do your will. They don't know the law about the estate. They don't know the law about anything. Their forte is numbers. I don't do numbers. I do words, and I know the laws. So I would never ever advise somebody to get a financial planner to do the will. Any decent financial advisor has a list of estate lawyers that they can refer you to, and they should refer you to. And I have excellent relationships with dozens of financial advisors who refer to me and trust me to deal with their clients, and that's the appropriate thing. Often I'll work with accountants about advanced estate planning, about how to save taxes for their children, in the case of capital gains and income tax and RSPs and et cetera, et cetera. It can get quite complicated when there's step families involved, when you're trying to equalize things. So, so I do work with financial advisors and accountants, but they shouldn't be preparing the will. They don't know the laws, so they should be working together with the lawyer to do that. So. Sorry, I'm just going through the list of questions that everybody gave me, and make sure that I answered them all. So my best advice is to sit down and talk to your family about this. Speak to a lawyer and make sure that what you have in writing now, if you have something, it reflects what you actually wish to happen. That's my timer that says I only have a couple minutes left. Make sure that what you have is actually what you want. So the first thing that I do when somebody comes to me with an older will is to tell them in plain English what it says. And it says, okay, it says here that your wife gets everything. And then when you pass away, your kids get everything. But if your kid predeceases you, your grandchildren don't get anything. Is that what you want? And usually that's not what they want, and they need to update their will. So that's a common scenario. But lots of people, they look at their will and they don't really know what it says, and they need somebody to interpret it. And I'm happy to do that. That's why I offer free consults, so that you can come in and say, this is what I want it to say. Does it say it? And we can change it. And often it says exactly what they want it to say. So I say, that's great. You're fine. Let me keep a copy here for you, or the original, and we can take care of it for you. And often people have a will and don't have powers of attorney, so we're able to help them with that, because that's a really hugely important aspect of personal planning. So if you'd like to meet with me and chat with me, of course, Ask Anonia knows how to reach me, but my phone number is 249-888-6647. And my email is tracy.rynard@devrylaw.ca, tracey.rynard@devrylaw.ca. So I'd be happy to hear from any of you, and every one of you actually. And I hope I do get to meet some of you, and I hope that you enjoy the rest of the program today, and that you found this helpful. And I know I didn't answer every question, but hopefully I answered some questions and you got some good information. So thank you for your time today, and have a great rest of the day. Bye.